We have more for your ears only. I'm David Alpern.
I'm Eddie Robinson with this quote from the news. For now, what China has done has helped. That was Ali Reza Nader, an Iran analyst at the RAND Corporation, after the U.S. granted China and Singapore waivers from financial penalties for continued oil purchases from Iran, albeit at lowered levels. But stepped-up Western sanctions still failed to halt Tehran's nuclear development program. Now this.
A serial child predator who committed horrific acts upon his victims, causing lifelong and life-changing consequences for all of them, has been held accountable for his crimes.
This monumental case, in many ways, will change the way business is done in many institutions, be they religious institutions, educational institutions, day camps, whatever, where people will not protect predators any longer.
After Pennsylvania Attorney General Linda Kelly announced multiple child abuse verdicts against former Penn State assistant football coach Jerry Sandusky, investigations continued into the complicity of others in the self-protective university community, spurred by last week's disclosure of potentially incriminating emails on Penn State Sandusky's strategy more than a decade ago. And the likelihood some might be held responsible was increased by the precedent set almost simultaneously in Philadelphia, where District Attorney Seth Williams won a conviction against Monsignor William Lynn, a former bishop's aide and the highest-ranking Catholic Church official yet found guilty of child endangerment for not doing enough to stop abuse by other priests.
The two cases were clearly likely to encourage more victims of similar abuse to come forward and be believed, while making institutions of all sorts more cautious about cover-ups. Equally promising is a variety of research indicating that rates of child abuse around the country have been falling for the last 20 years by more than 60% from 1992 to 2010 alone. To discuss added impetus from the Lynn and Sandusky cases, for your ears only, we're joined again by Florida criminal attorney and court commentator Janet Johnson. Welcome back to our program.
Thanks for having me, guys.
Let's start with the Sandusky trial itself, where it has emerged the judge refused a delay requested by the defense lawyers who tried to quit the case even before jury selection. Are these good grounds for an appeal of the 45 guilty verdicts?
Well, I think what they were trying to say by withdrawing or trying to withdraw is we cannot be effective. And ineffective assistance of counsel is a good ground to have an appeal granted. 10 months is a very short amount of time in a case with 10 victims, 52 counts. I was surprised the judge didn't grant it because normally they err on the side of giving the defense extra time so they don't have an appellate issue.
Defense lawyers said they did not call Sandusky himself to the stand to avoid rebuttal testimony by one of his adopted sons, who claimed after the jury was sequestered that he too was abused. But a retired judge told me his testimony might not be permitted because he had sat in court for much of the trial.
Yeah, in court, we invoke a rule of sequestration. Both sides usually invoke it. I do automatically whether the other side does or not, which means that all witnesses who are expected to testify are sequestered from each other and from hearing any testimony throughout the trial, so they would not be in the courtroom. There is an exception for certain types of witnesses. Experts can listen so they can comment on the testimony and, know what was said. And victims generally are allowed in the courtroom because they have a constitutional right to sit and hear the testimony.
The defense raised the issue of mental illness only in trying to explain some emotional letters from Sandusky. Could that defense be expanded in the sentencing phase to shorten what would otherwise surely be a life behind bars for a man of his age? Is it too late to seek hospitalization instead of prison?
Well, it wasn't an insanity defense, and normally the only time a defendant is hospitalized is if he's found not guilty by reason of insanity. They specifically didn't do that, I suspect, because they were denying culpability throughout. He constantly said he didn't do this. And what they used that defense for was to explain the letters, so that they were basically saying, look, he didn't molest any children, but he did write these letters. We can't deny them. They're here in writing and emails. And this is why he wrote those letters. I don't think it's a great mitigator in sentencing because, quite frankly, I don't think anyone believed it in the trial. But there'll be some sort of mitigation put together. It's always an awkward situation, sentencing, because they've been denying, and now you're asking the judge to take some sort of, sympathy on him and not give him the maximum. But, he's still looking at 100 years in prison.
The emails revealed last week were exchanged by two Penn State officials already facing charges and the former university president. They suggest not making official reports about a 2001 report of abuse by Sandusky after a conversation with the late head coach Joe Paterno. What was your reaction?
Oh, it's a smoking gun. I mean, it's so terrible for them in their civil trial, which is certainly coming up. There are civil lawsuits being filed, I think daily. And one of the most startling things is they decided that the more humane way to deal with this was to deal directly with Sandusky. And when they were talking about humane, they were talking about towards Sandusky, not towards these children who are saying he molested them. But they also said in the email that the downside for us, if he doesn't get the message, because I guess they were trying to send Sandusky a message, is that if he doesn't get the message, then we're vulnerable that we didn't report this. It's terrible, terrible, terrible. I mean, I don't see how in a civil case anybody doesn't win against them, no matter what the claim is.
A court in Oregon recently ordered the Boy Scouts of America to release 20,000 pages of files on abuse by adult volunteers in various locations. Do you think the verdict against Monsignor Lee in Philadelphia may lead to criminal charges or civil suits against Boy Scout leaders who knew about the reported abuse as well as against the alleged abusers?
What's difficult is, and normally you see these civil lawsuits going forward because in years past there were statute of limitations that barred most of these claims. So I don't know. I went to law school in Oregon. I don't know what the statute of limitations is on these charges, but generally they go forward with the criminal first if they at all can. But if they can't, they go forward with the civil because the statutes already ran on the criminal. So I suspect that's what was happening here, is that I think the statute of limitations probably ran.
Do you think the verdict against Monsignor Lee will lead to less covering up by institutions generally, since he was in a supervisory position, not the abuser himself?
Yeah, I mean, this is kind of the hope in civil lawsuits, starting back in the Pinto lawsuit, that you make it so expensive for a company or an institution that when they do something wrong, it's so expensive that they don't ever do it again. Or, they make the criminal punishment so hefty that they don't do it again. I guess it sends a message, and I hope that people follow it, but I think that the instinct is still what that email says, is let's try doing this the quiet way and hopefully we never get caught. Still think there's going to be a percentage of people that think they can get away with it.
Janet Johnson is a top criminal lawyer and court commentator in Jacksonville, Florida, and at janetejohnsonlaw.com.
Quote from the news, "I don't deny we have our differences." That was Fayez Sarraj, a prominent opposition figure in Syria, before yet another meeting of rebel factions after dramatic attacks on government targets in the capital, Damascus.
Next, old is new again on TV this summer, for your ears only.